And the board, please. Honorable Supreme Court of the State of New Mexico.
Morning, you may be seated. Thank you. Good morning. We're here in the matter of S-1-SC-40872. Protect Tesuque versus Kenney. Counsel, you may enter your appearance and begin your argument. You have 17 minutes in opening. You may proceed.
Good morning, Your Honors. Tom Nass on behalf of the petitioner, Protect Tesuque. May it please the court. Your Honors, this case fundamentally is about the NMED, the New Mexico Environmental violation of the doctrine of separation of powers set forth in Article 3, Section 1 of our Constitution, by abrogating the legislative command to apply the Environmental Improvement Act and the liquid waste regulations to discharges of liquid waste. Instead, the Environment Department, in analyzing current application for the discharge of 30,000 gallons per day of liquid waste, is analyzing the permit under the earlier enacted Water Quality Act and the superseded ground and surface water protection regulations.
Council, is there anywhere explicitly stated in the statutes that the Liquid Water and Waste and Disposal Act is superseded by the later enacted statute?
Your Honor, what is set forth in the statute, the Environmental Improvement Act, governs all dwellings established.
I understand what it says. Is there anywhere an explicit statement that the earlier enacted statute is superseded?
No, Your Honor, but we'd have to go to a different law enacted by our legislature, which is the Uniform Statute and Rules Construction Act, which provides that the later enacted statute is going to govern over the earlier, and the more comprehensive statute or rules is going to govern over the more general,
If you can't reconcile them.
if you can't reconcile them. Correct, Your Honor.
Okay.
But clearly, you want to give effect to both, which is what we want to do. That is also the statutory, uniform statutory rules.
How does your approach to this give effect to both? Because one is much more restrictive in terms of the amount of effluent, and interestingly is less prescriptive in terms of the procedure that has to be followed. You're asking for a lower standard for your client in kind of bringing this case forward.
Your Honor, I would respectfully disagree with that. You're actually asking for a higher standard of more prescriptive controls on the disposal of liquid waste. And so, in answer to the first part of your question, Your Honor, what happens here is the liquid waste regulations and the Environmental Improvement Act, which the legislature incidentally adopted 4 years after the Water Quality Act, with the knowledge that the Water Quality Act was not sufficient to protect against the myriad unknown contaminants set forth in liquid waste. So prescriptive controls were necessary. And I would suggest, Your Honor, respectfully, that those prescriptive controls are more protective of the environment, because the Environmental Improvement Act and the liquid waste regulations require the prevention of pollution before it begins.
Can I ask you a question? I'm going a little off, but it's important to me about process. The BL Santa Fe brought up whether this was ripe for a decision, and I wasn't satisfied with the reply you gave. Why this petition was filed before the May 19th hearing, a final decision has not been made, and there's a mechanism in place to appeal to the Court of Appeals once a final decision is made. Why should we hear this now before the process has been completed?
Your Honor, it's vitally important that the court hear this issue now, because it's an extreme matter of public importance, and any appeal from that hearing would be illusory in terms of granting.
But we don't know what the commission's going to do. If they deny the permit, this all becomes moot, doesn't it?
Your Honor, what the commission is going to do is look at the permit in the context of not applying the liquid waste regulations at all, but only applying the ground and surface water protection
Right,
regulations.
but if they apply that law only and deny the permit, we don't need to be here.
Your Honor, with all due respect, there is very little chance that they would deny that permit, because under the ground and surface water protection regulations, all BL Santa Fe has to show, this is important, answer this question, all they have to show is they're not going to violate a 3103 numerical standard for contaminants in situ.
Do we want to start doing that, where we do not require parties to go through the required process, the required both on appeal and administratively, and we start hearing cases before the process is complete? I'm a little concerned about that.
Your Honor, with all due respect, I think your points were taken. However, I don't think it's pertinent to the current situation. The reason being is because the Water Quality Control Commission doesn't have jurisdiction, one, to even adjudicate matters under the liquid waste regulations or the Environmental Improvement Act. That is vested in the EIB. So we would have to appeal to the Water Quality Control Commission and sit there and do nothing. Secondly, as this court has previously pronounced on numerous occasions, an administrative agency does not have authority to adjudicate constitutional issues unless the enabling statute expressly.
But the Court of Appeals does. I mean, I think that's Justice Zamora's point, is the Court of Appeals is just as equipped at this juncture to answer this question. And mandamus, pretty extraordinary relief, and we exercise that with great caution. And here, we don't know what's going to happen. And you have an available remedy as soon as the decision is made. So this is not a situation where there is no remedy once the proceeding below is complete.
Your Honor, there is no meaningful remedy once the proceeding is completed, because what would happen during the time it would take to go to the Water Quality Control Commission and appeal there, we would do nothing during that appeal.
Mr. Nasco, let me ask you a question, based on the briefing of your opponent. In their briefing, they specifically state that the existing permit would stay in effect through the entire appeal process. So there's no reason for us to interfere right now. Do you agree with that?
I do
No,
not,
let me break that up. Do you agree with their statement that the existing permit would remain in place through the appeal process?
Your Honor, that is precisely the reason why we need this court to intervene on mandamus. So any chance of that existing permit remaining in effect won't be realized.
You're not answering my question. Will that existing permit remain in effect through any appeal process?
Your Honor, we would take measures to try to ensure that it does not remain in effect. The Environment Department's position, I can tell Your Honor this, is that it would remain in effect, because they would be what we call.
So they would maintain the status quo pending appeal. This permit has been renewed 7 times. And so suddenly through this, this is, I think, the only way you can get to mandamus. You're worried about what might happen if the status quo isn't maintained at some time in the future, while you're trying to appeal the decision. I think that is the basis of your claim here for mandamus.
It is not, Your Honor. The status quo would not be maintained, because they would be allowed discharge under the current application for the 30,000 gallons per day liquid waste.
Where do you get
Where
that
do you get that?
authority? Tell me what, because they're saying they can't.
Your Honor, that's a great question, and thank you so much for asking it, but I'll tell you where I get the authority. The Environment Department's allowed them to do it pending resolution of the permit process.
So under the status quo, as I understand it, under the 2019 permit, that's been extended during the pendency of these proceedings, correct?
More than that, Your Honor, their ability to discharge under the current application has been granted temporarily.
Are they,
by the
are
Environment
they
Department.
discharging 30,000 gallons per day?
They're now authorized to do so.
Not?
They are authorized to do so. Your
Are
Honor.
they?
Yes, they are authorized to do so.
No, are they doing it? I think that's the question. Not are they authorized? Are they doing it?
We have no way of knowing that, Your Honor. We have no way of measuring what they're actually putting into the disposal field. We have no method whatsoever to find that out.
So once a decision is made, you're saying it goes into the Water Quality Board?
Water Quality Control
Water,
Commission. Your
yes,
Honor.
thank you, sorry.
Sorry.
And then at that point, you'd be able to appeal it to the Court of Appeals and ask for a stay if needed. I mean, I'm just saying, if it was outside this process, that'd be the process that would normally happen.
The process, as I envision it, Your Honor, it's a unique process, because we would be essentially sitting mute at the Water Quality Control Commission hearing, because they don't have jurisdiction to hear our issues. Only this court would on mandamus. However, once we appeal to the Court of Appeals from that decision, and we go through that 1 to 2 year process in the Court of Appeals. In the meantime, the harm would be irreparable to the downstream neighbors while the discharging is occurring without complying with the constraints imposed by the liquid waste regulations.
Counsel, let me ask you, if we were to agree with you that they had to go get a liquid waste permit, am I correct that your client doesn't have an opportunity to object and there's no hearing? What are you asking for under those regs?
The liquid waste permit, you are correct, Your Honor, in that regard, because the liquid waste regulations are specifically tailored to require particular engineering requirements on the sizes of the disposal fields, on the rate limitations set forth in the disposal fields, on how many you can have, how far the setbacks have to be from water courses. All the boxes have to be checked.
But you don't have any ability to object if they receive an approval under those regs.
We would be able to go to the Environment Department internally, and as any member of the public could, and review the permit and make comments on it. We would not have a hearing on that under the liquid waste regulations.
Where in the regulations are you allowed to make comments?
We are, Your Honor, it's a matter of practice. It's how the Environment Department runs its permitting operations, that everything is public, and every member of the public through a IPR request is able to make comments on that permit application.
But if they choose to disregard your comments, you don't have recourse.
Your Honor, we wouldn't need recourse under the regulations, because if they followed the constraints imposed by the liquid waste regulations, we wouldn't have the issue that we have today. That would be overtaxing the aquifer in one location, use of an undersized leach field. Under the liquid waste regulations, BL Santa Fe would require 6 separate disposal fields, each separated by appropriate setbacks. They would be prohibited from introducing hazardous waste into the waste stream. We don't know, because of the aggregation of waste of 82 separate property owners, what is actually going into the waste stream. Each one would have individuated responsibilities for that. So the boxes would be checked, prescriptive requirements would be met, and we would be far better protected.
So as I understand it, the public hearing was held May the 19th and May the 20th. The transcript of the hearing was completed on May the 27th. Did you sit mute at the public hearing,
Your Honor,
or did you participate?
we participated under the terms of the grounded surface water protection regulations. We did not participate in assert or argue for any application of the liquid waste regulations, because we were precluded from doing so by the hearing officer. We did cross-examine their expert witnesses, and that's what we did. We did not present any technical testimony on our own, because we had none to present.
And based upon the briefing, this was a hearing that you requested.
Your Honor, under the regulations, the Secretary of the Environment makes independent determination whether it's sufficient public.
You requested a hearing.
You don't request a hearing, Your Honor. You request interest in the permit. You might have questions about it, and the Secretary is duty bound to set it for a hearing in that event. So that is how that works. But Your Honor, I think another question here, which is important, and Your Honor, have been asking these questions, which I think get to it. It's a 5,000 gallon per day limitation. Is that a jurisdictional limitation? It is not a jurisdictional limitation. It's found nowhere in the Environmental Improvement Act. Environmental Improvement Act itself applies to all dwellings, establishments, and groups. All.
But if we were to try and discern what the 5,000 limit means, it would be a different legal question before the court. You would have to come in front of us and argue that the rulemaking is arbitrary and capricious to eliminate that 5,000 cap. And that's not what's been presented to us. You want us to jump past that and kind of ignore that that's there. And that's a struggle. I mean, I think it's an important question. Is mandamus isn't the avenue to challenge a regulation for being arbitrary and capricious. That's a different process.
Oh, Your Honor, we are definitely not challenging how regulation is being arbitrary and capricious.
You're saying it doesn't mean anything.
Wonderful.
No, but you think that the 5,000 limit doesn't mean anything.
Oh, it means a lot, Your Honor. It is the maximum rate at which liquid waste can be disposed of in one system. Regulations are very clear that if you choose to discharge more than 5,000 gallons per day, you can do so. Section 302C of the liquid waste regulations specifically acknowledges that you're entitled to seek multiple systems to accomplish that objective. So 5,000 gallons.
But
is simply-
5,000 gallons, that particular thinking was to deal with smaller users, residential and the like, not something this size. And it says you come in front of us one time We approve it, and it can be experimental, it can be all kinds of things. And then you never have to come in front of us again because we get that you're a small time user. The end. You've got your permit, you're good. That's quite different from what BL is subjected to and having to renew the permit over and over again because they're not a small time user. And so if you look at the intent behind the regulation, it's not to deal with the BL, it's to deal with somebody who's got a house. Really different situation.
Your Honor, that is not the intent of the Environmental Improvement Act, nor is it the intent of the liquid waste regulations. There is nothing in the act, and there's nothing in the regulations which suggests that it applies only to small quantity generator. As a matter of fact, to exempt large quantity and the most hazardous generators is antithetical to the purpose of the Environmental Improvement Act, which is to confer optimal health on the citizenry, and the liquid waste regulations, which is to prevent contamination. There is nothing in the act that imposes a jurisdictional limitation of 5,000 gallons per day. And that's why we are here, Your Honors. So it is clearly.
You're over time, so let's go ahead and wrap up. Yep.
Thank you, Your Honors. I would just point out, if I may, that the Environment Department believes, acknowledge that the gallon limitation has changed over time based on technology. And with that, Your Honors, I would respectfully request that the court grant the petition and direct the Environment Department to apply the Environmental Improvement Act and the liquid waste regulations to this discharge.
Thank you, counsel. We'll hear from the Environment Department, please. You have 10 minutes.
Good morning, Chief Justice and Your Honors. May it please the court, Crystal Weatherly for the New Mexico Environment Department. There are 5 reasons why the petitioner does not have a clear legal right to a writ of mandamus. The first is that this is not an emergency or an extraordinary circumstance. Bishop's Lodge has been discharging under its groundwater discharge permit for 46 years.
Let's clarify the record. What are they allowed to do under the permit? What are they allowed to do under the application? And what are they doing?
Bishop's Lodge is allowed, well, currently they are allowed to discharge up to 14,000 and some gallons per day. So they are not yet allowed to discharge up to 30,000 gallons per day. That's what the draft permit encompasses.
And they are allowed to discharge in accordance with I would describe as the status quo process for discharge, the way they were discharged.
That's correct. This is a typical groundwater discharge permit that has been issued under typical procedures pursuant to the regulations.
Okay, continue.
So can I follow up, Chief? So if Bishop's Lodge prevails and then there's an appellate process after that, what will Bishop's Lodge be able to do during that interim, which can take 2-3 years? Will they be operating on, will they be able to discharge 30,000, or will they still be held to status quo until the legal wrangling is over?
If an appeal is filed, it does not stay the permit. So the 30,000 gallons.
It's not stayed.
It does not stay.
Is there a mechanism to ask for a stay?
Yes, they can the petitioner can request a stay. And if the court grants that stay, then
what happens while it's in front of the Water Quality Board, that interim step that it was described by petitioner?
it is not stayed.
Okay, thank you.
They cannot ask the board for a stay,
They can ask the board for a stay.
and the board could grant a stay in its discretion.
Correct.
And if they deny the stay, the petitioner could still ask the Court of Appeals to review that decision and ask for a stay.
That is my understanding.
Okay. Thank you.
This is not an extraordinary circumstance, but a writ of mandamus would have an extraordinary impact on smaller systems and residential property owners across the state, as well as the WQCC and EIB's jurisdiction over wastewater disposal. Number two, the case is not ripe for this court to review. Number three, a resolution can be obtained through other channels. The administrative proceeding currently underway, for which the petitioner is actively participating, and a petition for rulemaking or review of the existing rules with the EIB or the WQCC. Number four, granting the writ of mandamus would essentially be ordering the Environment Department to violate the rules as written and the legislature's intent. And number five, this is not a purely legal issue.
I want to go to kind of where we left off with the petitioner and the argument that the petitioner was making that the cap within the liquid waste scheme at 5,000 gallons or less of liquid waste per day, that applies to every entity that is disposing of liquid waste. They would just have to get 30, they'd have to file numerous different petitions and kind of cobble them together. That's what I took away from that argument where we left off. What is NMED's view of the 5,000 gallons or less of liquid waste per day language? Is that a cap? Is it a suggestion? Does it require multiple permits to get to 30,000?
Thank you, Your Honor. Petitioner's entire argument hinges on a misreading of the definition of liquid waste and the scope of the liquid waste regs. So the liquid waste regulations outline detailed requirements for the disposal and treatment of liquid waste, which is defined as wastewater generated from any residential or commercial unit where the total wastewater received by a liquid waste system is 5,000 gallons per day or less. So anything over that threshold is no longer considered liquid waste for the purposes of the liquid waste regulations. The scope, which is outlined in the regulations, states that it applies to on-site liquid waste systems and effluent from such systems that receive 5,000 gallons per day or less, and that do not generate discharges that require a discharge plan pursuant to the ground and surface water protection regulations. And
so would this be akin to having like a septic tank?
Correct.
As opposed to a leach field?
Well, a septic tank could have a leach field. What I'm learning that term.
Us too.
Thank you. I am learning that term is a bit of slang for a disposal field, which, you know, a septic tank would have. Bishop's Lodge's system has. I'm not sure if that answered your question.
I'm not sure. So then why? So you're saying it does not, for the Liquid Waste Act to apply is for those that do not generate discharge. I wrote it down when you said it.
5,000 gallons per day or less. Their
There's
system
still
is
discharge.
Yes, there's still
Okay.
discharge.
So petitioner seems to argue, and I'm trying to wrap my head around this from both perspectives, that the liquid waste regulations are much more onerous and stringent than what Bishop's Lodge is currently permitted under. Is that a fair assessment?
No, Your Honor, it is not.
Why not?
The department's position is that the technical requirements of a groundwater discharge permit are far more protective of groundwater than the liquid waste regulations. Septic tanks are actually the #1 source of groundwater contamination in the state. And the liquid waste system is what we call a one and done.
That's what that whole, you don't have to renew it.
That's
thing.
right.
Yeah.
You have a permit, you get your system. It's very prescriptive. You choose a system that complies, and a homeowner can install that system themselves. There's no ongoing oversight, no hearing, no renewals, no checking, no sampling, no monitoring. It's designed to be protective until it isn't.
Can I ask,
Yes.
the 5,000 gallon per day limit, or you quoted from the regulation, as from the definition of liquid waste
Yes.
to get you there.
And
What's the statutory basis for having a $5,000 limit?
you know, there is not a statutory basis for 5,000 gallons. What the statute does is it authorizes the Environmental Improvement Board to promulgate the regulations for liquid waste. That's it. And so the Environmental Improvement Board has promulgated these regulations for liquid waste. And in 2014, it did so in concert with the WQCC, who revised their regulations for ground and surface water protection. And those regulations reference the liquid waste regulations as an exclusion. So a groundwater, let's see, the groundwater regulations do not apply to a system that is required to be under the jurisdiction of the liquid waste regulations. And it seems very circular on the face, but what is very specific is that 5,000 gallon per day threshold.
But it is specific, but I think the question is where that came from and how that's challenged. It seems to be they've drawn the delineation based on volume and not what's in the water. And that's what I'm, I don't know whether that's tone of Senior Justice's question, but it is mine. By creating that 5,000 gallon rule, you seem to have delineated what is and what is out of each category,
May I answer that?
I guess.
It's my understanding, and again, I'm learning, it's my understanding that the 5,000 gallons per day is not based on a technical requirement. It used to be 2,000 gallons per day, and it was increased to 5. And my understanding is that that was done because most of the systems at the time for residential property owners and small systems fell under 5,000 gallons per day. And that the EIB and the WQCC decided that those were more appropriately governed by the liquid waste regulations and not the onerous regulations of the Water Quality Act.
Thank you. Any other questions?
Can I ask one more question?
Thank you.
Is it accurate to say that one of the differences between the liquid waste regulations and the water quality regulations is that under the liquid waste regulations, the 5,000 gallon limitation does not require any sort of water treatment or the owner is not required to do anything to treat the water. But when you start getting into water quality control, there are specific treatment requirements to bring the water back to a certain condition. Is that accurate?
If I understand your question, I think so. Although I would say that the owners would not be drinking the water coming out of their liquid waste.
No, but they're not required to do anything to bring it back to a better condition. They're not drinking it in the water quality circumstance either. They're
Correct.
using it to water grass and things like that.
If their system fails, they need to take steps to
Right.
remediate that issue.
But there's not an ongoing treatment requirement like there is under water quality control.
Correct. There's not ongoing oversight by the department.
Okay.
Thank you.
Thank you, Chief.
Thank you.
Thank you, counsel. Hear from the real party units, please. You have 10 minutes.
Good morning, Mr. Chief Justice, and may it please the court. I'm Chris Mulcahy, and I represent BL Santa Fe, the real party in interest, and the permittee here today. If I may just jump in, there's been a lot of discussion about what the liquid waste regulations require versus the water quality. regulations require. And Justice Vargas, the question came from you just a moment ago about water treatment under the liquid waste regulations versus under the groundwater protection regulations. And to answer your question, you are correct. So under the liquid waste regulations, you have generally a septic tank and a leach field. That's all you have. And what that septic tank does is it does one treatment step. If it's installed right, if it's watertight, if it's airtight, it will do this. Oftentimes, as my colleague, Ms. Weatherly stated, this is not correct, and septic tanks and leach fields are the #1 polluter of groundwater in the state of New Mexico. All the septic tank does is separate solids from liquids. The solids go to the bottom because of gravity, the liquids stay at the top, and then they are discharged to a leach field. The purpose of a leach field is to perform treatment. We don't have a leach field, even though that term is used sort of as slang in the wastewater world. A leach field is for treatment. The soil is for treatment. We have a disposal area. We don't need further treatment. When the water is discharged from our membrane bioreactor wastewater treatment plant, it is fully treated. It has gone through 9 treatment steps to remove organics, inorganics, bacteriologicals, viruses, and then it's UV disinfected. So we remove 99.99% of all viruses like COVID, HIV. We remove 99.99%.
And that additional, the fact that you have a treatment plant is because of the quantity. Quantity makes it more perilous to discharge into the ground than somebody's house.
That's exactly right, Justice Bacon. And after we go through this treatment, what I think is very important is the quality of our effluent is what's considered Class 1A reclaimed wastewater. That's wastewater so clean, you can use it to irrigate food crops. So when we discharge it to our disposal field, we're not looking for further treatment. We're looking just to get rid of that water. And we don't use the disposal field 12 months a year. We only use it 3 months a year during the winter months when the ground is frozen and we can't irrigate with it. There was also a number of questions from the court that I would like to address about what the permit requirements are and what would happen with the permit. The permit is currently administratively continued. What that means is at the time, under the water protection regulations, your permits are good for a maximum of 5 years. That is not true under the liquid waste regulations, by the way. If you get a permit under the liquid waste regulations, it is one and done. You never have to go back to the NMED. Why that matters is going back to the NMED every 5 years demonstrates that we as permittees are and can continue to meet the water quality standards.
Right, but the difficulty with this argument is I'm hearing this term aggregation. So you can say one and done, but your volume is below 5,000, right? That would be one and done. The aggregation argument I hear is, well, we're taking a lot of little ones and combining it in order to get away from the setback requirements, let's say. So I appreciate the fact that it's one and done, but the volume for your client is quite different from the one and done permit, right?
That's correct, Justice Thompson. So our client, also to clarify the record, we are not authorized to discharge 30,000 gallons per day.
Okay.
We are not discharging 30,000 gallons per day. And you can know that because our discharges are metered and we must report them to the NMED. So anybody can file a NIPR request and get those discharges and they will be less than 30,000 gallons a day. The aggregation issue is the liquid waste regulations on their face only apply to systems that receive less than 5,000 gallons per day. The court does not need to go into the construction argument, the primacy argument. Those regulations are clear on their face. The statutes are hollow. Both the Environmental Improvement Act and the Water Quality Act do not state any sort of volumetric limitations.
They delegate the entire decision-making to NMED.
That's correct, Justice Bacon. And the reason we do that is,
How
I'm sorry?
do they, I have to say it is although is your broad is another term.
Sure. Yes, Your Honors. Broad is a good description of it. And the reason that they do that ostensibly is because NMED is the expert on water quality treatment, not the legislature. NMED is the expert to say, this is the better system to treat and ensure we have protection of water resources in a state that's limited in water resources.
And that goes through a rulemaking process that's replete with comment and pushback and everything else before they become final, correct?
Yes, Justice Bacon, you are correct. It goes through a full rulemaking process. Any interested stakeholder may participate, may put on experts. And in fact, we know that that happened with the most recent amendments in 2014 because NMED included in their briefs some of the testimony from that rulemaking process.
So you went through quite a bit of detail about the process, which is actually quite interesting that your client uses to get rid of waste. I guess what I'm wondering is, was that part of the application? Was that part of the hearing? Where did all of this factual information come out? And again, I think you heard before, the process is important to me. So just wondering, was it at the hearing? Was it after? There's affidavits attached to our briefing. And I also wondered if that was part of the record below.
Thank you, Justice Vargas. Yes, and I heard your question before about why is this matter ripe? And the answer is it is not ripe. So all of the information about how we treat the water, what is the quality after treatment, what does the treatment process look like, what does the draft district permit require now and into the future, that was all brought out in expert testimony at the hearing. That was the hearing that petitioners requested. And at the hearing, petitioners put on no evidence whatsoever for their case. And their position is, well, we take the position that the liquid waste regulations apply and not the groundwater protection regulations. But we all know in terms of process, New Mexico is an alternative pleading state. And so they could have easily said, we believe that this is permitted incorrectly, but here's our experts, about how the liquid waste regulations are more protective. They didn't do that. There is no evidence in the record whatsoever that the liquid waste regulations are more protective.
Well, petitioner says that the hearing officer didn't allow them to do that.
That is incorrect, Justice Bacon. The hearing officer allowed them to put on any case that they wanted to. The only thing that was decided pre-hearing, Justice Bacon, was which set of regulations apply, because that also dictates how the public process moves forward. If it was a liquid waste permit, there actually would be no public hearing or public process, because those regulations do not permit public comments, public notice, or a public hearing.
Yet you would have neighbors fighting with each other over every single septic tank permit.
That's correct, Your Honor. And just another point on why the groundwater protection regulations are the better standards. Right now, our draft discharge permit is 33 pages with 65 conditions that we have to meet. We have to quarterly sample, monitor, and report on a host of constituents. We have to tell the Environment Department what those concentrations are. And when we're irrigating, we must do that weekly. If we had a liquid waste permit, we would do none of that. In most instances, a liquid waste permit, if you've ever seen one, is 1 to 2 pages maximum.
In these hearings, has there been any predictive testimony about what would happen under the $30,000 gallon per day permit?
Yes, Your Honor. Justice Vigil, there was testimony from 7 experts that talked about how that is still protective of groundwater quality. And you don't know this because
I don't have the transcript.
You don't have the transcript, and petitioners prematurely filed this case. But in that record, the Bishop's Lodge has actually had discharge permits for larger amounts. In fact, we've had discharge permits in the past for up to 60,000 gallons per day of discharge. So 30,000 gallons is actually a step back. We've had 7 previous permits, and this will be the 8th if it's renewed. I'm close.
When did you get 60,000 gallons per day?
I'm sorry,
When did you have 60,000?
in the early 90s? Okay, I'm sorry, I see that I'm close to out of time. So if I may just finish, Your Honors, for the reasons we've stated in our briefing and here today, we respectfully request that the court deny Protect Tesuque's petition for a writ and let the administrative process that Protect Tesuque specifically requested proceed. That's also supported by the most recent case law, Concerned Citizens, that we submitted supplemental briefing and notice of. Thank you, Your Honors. I appreciate the time.
Thank you, counsel. 3 minutes on rebuttal.
May it please the court. Your Honors, I'd like to clarify one item if I may, and that's this notion of exclusivity. As if this is an either or situation. It's not. It's not an either or situation. We're directed by the Uniform Statute and Rural Construction Act to give harmonious effect to both the Water Quality Act and the Environmental Improvement Act. The Water Quality Act itself specifically states it's not exclusive. Its remedies are cumulative. The liquid waste regulations under the Environmental Improvement Act are the baseline requirements for the discharge of all liquid waste, whether it's treated or untreated.
So let me ask you this question. Tell me if I'm not forming the question well, because that's entirely possible. If we are writing a rule for this case and for others, if we were to accept this concept, what would we be writing for other large dischargers? Meaning, it seems to me that just making the senior justice's question, you're simply saying these are irreconcilable. You've got to go with the newer over the older. And the newer law and regulation governs not just this discharge, but all of them. Is that the rule you're asking us to write?
Your Honor, you phrased the question perfectly. But the answer is no. They are not irreconcilable. They are harmonious and can be applied harmoniously. The liquid waste regulations apply to all dwellings, establishments, people who seek to discharge, regardless of volume. You can have more than one 5,000 gallon per day disposal field. And Justice Bacon's question, you don't require multiple permits, you require one. However, once you comply with the engineering requirements of liquid waste regulations, which are prescriptive and designed to prevent contamination from occurring in the first place, you might have made a mistake. And you might contaminate groundwater and exceed a 3.103 standard in the Water Quality Act and the Ground and Surface Water Protection
The
Regulations.
mistake being what? A mechanical mistake?
Perhaps overloading the
But
aquifer.
that's got nothing to do with the permit.
It could, Your Honor.
If you install it improperly, that's got nothing to do with the permit that was given.
Correct, Your Honor, and here's why they work harmoniously, because if you receive the liquid waste permit, I'm trying to segue back to the Chief Justice's question, I did write it. That's the baseline requirement. However, you might also have to get a discharge permit if you exceed a 3.103 standard. And then,
Is that possible?
yes, it's possible.
How is that possible?
Your Honor, because the Water Quality Act is an abatement statute. It requires abatement. It allows contamination up to 3.103 standards. If you exceed those standards, it requires abatement. The liquid waste regulations tell you particularly that if you violate a provision of the liquid waste regulations, you have to go get a discharge permit as well. So they both work. And in the liquid waste regulations, are baseline requirements. Everyone
So
must
you would
comply.
only have to get a liquid waste or a water quality permit if there's a violation of the liquid waste permit?
No, Your Honor, if I may finish answering the question. If it were determined the testing of effluent, and by the way, there's only testing for two constituents here, chlorides and nitrates, all right? We don't know if these 82 aggregated homes are putting down their kitchen sinks. Could be turpentine. We don't have any idea. No one has any idea. But if it were determined that you're actually discharging contaminants into the aquifer, measured in situ in the aquifer, and there was a potential of exceeding a 3.103 standard.
But if there's, under the
You have to get a
Liquid Waste Act, there is no follow-up testing. I mean, there's a complete disconnect in the structure. So if you get your permit under the Liquid Waste Act, there's no follow-up, there's no testing, there's this whole host of protections. You just get to keep doing what you're doing. So
Your Honor, there's no protections currently under the Ground and Surface Water Protection regulations to test for anything other than chlorides and nitrates. So that.
but you're asking for no testing at all.
No.
That, to me, that is
If there
Nonsense.
were a condition in the system that alerted the operator to an upset condition, you would have to test. And if there were testing indicating a discharge, you would be kicked over to and the liquid waste regulations contemplate this, that if there is a violation of them and they are not sufficient to maintain the controls in the environment, you have to go to the ground and surface water protection regulations. So they're not mutually exclusive. They can work in concert, but there's no basis in the Environmental Improvement Act, none whatsoever. So to exempt large quantity discharges from the same requirements that everyone else has to comply with.
I'm reading from page 25 of your brief. The petition. You say that every domestic and commercial discharger of liquid waste must in the first instance comply with the requirements of the liquid waste regulations. Those who do so are exempt from further additional regulation under the GSWP regulations unless they discharge effluent that violates the water quality standards the GSWP regulations establish. But in the note I made on the side here, my note is that can this happen? Meaning there's no testing as we know under the liquid waste regulations. So how would anybody know whether the GSWP regulations are being violated?
All right, I see I've exceeded my time. I briefly asked the question. Thank you so much. Justice Field, if one were to comply with the engineering requirements of the liquid waste regulations and had appropriate sized disposal fields separated adequately and they were maintained properly, there is no reason to believe that there would be a violation of the water quality control regulations. However, liquid waste regulations contemplate that if there's a violation of those regulations, the Environment Department has the authority to move you over to the Groundwater Bureau and also require that you get a discharge permit. That discharge permit would likely include additional testing requirements for certain constituents, depending on which ones were violative of the act. So they work in concert together. The 5,000 gallon limitation that's changed over time from 1,000, 2,000 to 5,000. It's been a health and safety issue, not a jurisdictional one. So we respectfully suggest the court follow this court's decision in Sundell and State XRL EGOF and rule that the Environment Department can't pour new meaning into that EIA, and that the writ ought to be issued directing in the first instance that the liquid waste regulations and the Environmental Improvement Act be applied to this application for discharge. Thank you, Your Honors.
Any other questions? All right, thank you, counsel. I want to thank counsel for their papers and argument today. This is a petition for writ of mandamus. In this circumstance, the court will recess and conference the matter. If we're able to provide a decision for you, we will do that in open court. So I would ask that the parties remain close and in the courtroom, because if we decide to come back out, it's fairly quick. So I'd ask you to kind of stick around. If we're not able to reach a decision, we will notify the clerk of court and they will notify you. So for the meantime, thank you for your argument, and the court is in recess. Thank you. You may be seated. Back on the record of Protect Tesuque versus Kenney, S-1-SC-40872. Court has conferenced this matter and is prepared to rule. Court appreciates the pleadings and oral argument today by petitioner, respondent, and real party in interest. We are here on an emergency verified petition for writ of mandamus and a request for stay. We issued an interim order of June 9, 2025. The standard of review, well known for mandamus action, established in State XRL Sedell 1999 and MSC 019, dating back to State XRL Call versus Johnson. Must implicate a fundamental constitutional question of some public importance, great public importance. It can be answered on the basis of undisputed facts. It calls for a resolution that cannot be obtained through other channels, such as a direct appeal. Court, having considered the matter, will deny the emergency petition for writ of mandamus on the grounds that it does not meet the standards set forth in State XRL Sandell, including but not limited to an adequate remedy in law, with including an opportunity for administrative and court review. We will issue a short form of order following the recess. In addition, the court will vacate its June 9, 2025 order staying the matter. Any questions from petitioner?
No questions, Your Honor.
Thank you. Any from the respondent or real party in interest? Thank you again, and the court is in recess.